So, welcome everybody. Thank you for joining us this morning. We have a great webinar that we're going to talk about. We're going to be talking. I say we. You've actually come to listen to Chris rather than me. So he's the one with all the industry insights and everything. So he's covering the new privacy and data regulations. What could possibly replace GDPR. Chris is the CEO of the DMA. So the industry body for marketers around the world, and I look after the marketing at Spotler. Have done so for 10 years now. So I know the ins and outs, hopefully, of the marketing landscape, especially within marketing automation and software. Chris, if you can go forward a couple of slides, that would be great. Don't need to see our faces there. We always get asked, will the webinar be recorded? It absolutely will be. So you don't need to try and make loads of notes, but we will send you a copy of the recording. We'll also send you a copy of the slides. So you'll get those. Give us a couple of hours, hopefully, to tidy up the recording, but you'll get a copy of the recording, the slides after this is finished. We also have Q&A. So you can submit your questions using the question panel. So at the end, I can ask Chris any questions you might have about what he's presented. I'll also be on the Q&A if there's any particular questions that people might ask, and I'll be answering them throughout. But at the end, we'll try and have about half an hour of talking, and then a good bit of Q&A for any questions that you've got. I'm pretty confident, Chris, there'll be a number of questions for you at the end of this anyway, so we'll leave a good amount of time for that. But for those who don't know who Spotler is, I just want to take this opportunity to let you know that we are a marketing automation platform, a European-based platform, UK, Europe market, with over 10,000 customers using the products every day. Sending over billions and billions of messages. And what I mean by that, Chris, if you can go to the next slide, is not just email, but multi-channel. So Spotler have been on a growth panel of acquiring products, of whether it's a social media product, it's a CDP, email products, event software, AI software. So now we've got an all-encompassing platform for marketers to run their marketing automation out of. And what that means is it's one platform now where you can send your emails, you can do your cart abandonment, we can show you who's on your website, you've got your social media that you can syndicate and manage, you've got Spotler CRM where you can manage all of your leads and deals. We've got Spotler Connect where you can connect to your web shop or your store or CRM. So a very full-on marketing platform that enables you to perform all of your marketing activities. We try to give you the product to be able to deliver everything, but we also are aware that you might need support. So we've got a UK support team. You get account management. We have deliverability experts trying to help you get the most out of the products. And for those customers that can't, or not can't, but don't have the resources to do it themselves, we also have services and consultancy to help you along the way. My last couple of slides before I let Chris get into it is just, obviously, I'm always going to say great stuff about Spotler, but have a look at Trustpilot. And Chris, the next slide of G2 Crowd, there's some independent reviews on there that hopefully for some happy customers that give relevant and realistic reviews. So without further ado, obviously I said you're here to learn about data protection and what might replace GDPR. I'm not the person to tell you that, in my opinion. Chris, we've got Chris here today, CEO of the DMA. I will let him do his introduction, but all I can promise is I've seen his slides and there's some really interesting pieces coming up. So Chris, over to you. I'm going to go off camera, but I'll be in the background if anybody has any questions or if I need to butt in and ask you a question of any sort. If not, I'm going to leave you to do your piece and then we'll pick up at the Q&A at the end.
Brilliant. Well, thank you so much for that and that introduction, and thank you so much for the opportunity to speak to the Spotler community. Um, as Simon said, I'm the CEO of the DMA. The DMA is the voice of the data and marketing industry. We represent the industry to government, and we have a wide range of research, insights, and other services. But everything we do is really driven from our code of conduct. All of our member community commits to our code as an ethical framework for responsible marketing, which we launched back in 2014. And really, at the heart of it is putting the customer first, which is really a prerequisite for being a great marketer, but also fundamental in this era of technological change and data-driven marketing. And our five core principles, including respecting privacy, be honest and fair, be diligent with data, and take responsibility. Each principle is supported by a set of outcomes it's intended to achieve and some rules. So that's really important. And that approach to responsible marketing frames our conversation with government and regulators. Now, I had expected to be talking to you today with the Data Protection and Digital Information Bill very close to being completed, a bill which really had just about every amendment to GDPR and privacy and electronic communications regulations that our community of members had asked us to achieve during the consultation period. So we were scheduled to have the final report stages in the House of Lords on the 10th and 12th of June. But as you all know, an election was called on the 22nd of May, really putting to bed 3.5 years of consultation. Our members were very active. Even at the beginning, we held roundtables with as many as 6 department officials from what was now the Department of Science, Innovation, and Technology participating. From about October 2022, when Michelle Donnellan became Secretary of State for Science, Innovation, and Technology, I chaired the business advisory group on this bill, which included all the major UK trade associations, so the CBI, Tech UK, UK Finance, and many others. And what the bill was doing was reforming simultaneously 3 existing pieces of legislation in the data protection framework: the UK GDPR, the Privacy and Electronic Communications Regulations, and DPA 2018. We did have an opportunity to pass the bill. This particular instance, by the way, was the shortest wash-up period ever in the history of the UK Parliament. There was just 48 hours between the announcement of the election and the conclusion of the legislative process. And what happens during wash-up is where the parties can agree, then bills pass through without the normal full stages of final scrutiny and amendment. And in this particular stage, we know that the Labour Party had given the opportunity to pass this bill, but they wanted certain provisions removed, which were not really about what the bill had been about. They were provisions the government put in at the very last minute back in November at the request of the Department of Works and Pensions, that would enable some benefits fraud provisions, such as being able to look at everybody's bank account automatically who's receiving benefits, which seemed not appropriate to every party in the House of Lords, not just the governing party. But in any case, the bill fell, and we're now starting again. But I should note a couple of other bills passed that are important to marketers during the wash-up periods. The most important by far is the Digital Markets and Consumer Bill, and Digital Markets, Consumer and Competition Bill, which gives the CMA far greater powers to regulate, especially over the monopolistic powers of some of the technology platforms, and greater power over consumer law and its implementation, and taking that into account in the competition framework. So we launched immediately after that our 10-point election manifesto. And we're following next week with a open letter to all the political parties from a range of organizations. But I'll just quickly go through what we're hoping to achieve with the new government. Obviously, what we want to do is maintain high standards of data protection to build trust and confidence in the future of the economy and government services, bearing in mind that all businesses and all public services will be driven by technology, by AI, by data as we go forward. The most important point for our members has always been to provide certainty to legitimate interests as a lawful basis, to take a principles-based and ethical approach to AI, similar to the framework in our codes, give legal certainty to the recitals in GDPR. And I'll talk about that quite a bit as we go through, because the recitals in GDPR tell you how the text should be interpreted. But since 2016, mainly lawyers, compliance officers, the Information Commissioner's Office have ignored to a large extent the recitals, and it's really important that we get back to that. The most important thing for our members is to maintain adequacy with the EU, because most of our community has business on the continent, and the free flow of data is crucial to the free flow of trade. Very important to promote scientific research in academic and commercial settings, and I'll say a bit more about that. And we were hugely supportive about, back in October 2022, when the government created the Department of Science, Innovation and Technology, which brought together parts of the Department of Business and Trade and parts of the digital and data protection remit from the Departments of Culture, Ministry and Sports into a single department, which really oversees all the aspects of the society that have data at its heart, everything from scientific research, medical research, new technology, digital markets, and so on in one department with genuine expertise. And reform the organization structure of the ICO. And then a little bit on skills, because we have a robust education program around the skills in data, AI, and digital marketing. We have funding from the Department for Education to run digital marketing strategy boot camps. And we found some issues in how the Department for Education looks at skills within the workplace that we think makes it much more appropriate to be in the Department of Business and Trade. So what's happening next? We had last week the manifestos. We have the election on July 4th. The King's speech on 17th of July is going to be critically important, because that's when we'll know if there actually is going to be an AI and data protection bill. But it's our understanding that there may well be an AI and data protection bill, which would give us the opportunity to bring back the reforms for marketers that we had achieved in the Data Protection and Digital Information Bill. And when we look at labor, the Labor's Policy Forum really is the framework, and then they developed the manifesto, based on what their Policy Forum has published. But in the Policy Forum, they really have everything that we could have possibly wanted to hear that would support the amendments that we had in DPDI. So, and thinking back to the manifesto I just shared, ensure our world-class researchers and businesses have the data and computing infrastructure they need to compete internationally, or harness data for the public good, and introduce robust regulations that opens up data while enshrining consumer rights. That's the balance between innovation and privacy that we speak about quite often. Maintain Britain's data adequacy status. Make it easier for public services to adopt innovative technologies, and so on. Really everything that we would have hoped to see in a political party's approach to data and technology. But then in the manifesto, which came out last week, they said very little about all of those things. And what was said about data and technology and AI is fairly limited to a couple of things, but possibly broad enough still to enable them to bring forward a bill based on what they said. But what we can certainly look to is in technology. They say labor will ensure the safe development and use of AI models by introducing binding regulation on the handful of companies developing the most powerful AI models. So that's one point where they're certain to have some legislation that may create an opportunity for us. And obviously artificial intelligence, we will ensure our industrial strategy supports the development of the artificial intelligence sector and removes planning barriers to new data centers. So they want to enable more data centers in the UK by making it faster and easier to get planning proposals. But there's not a lot. There's not the robustness and the thoroughness that was in the policy platform. But what I want to talk about now is where we see the opportunities for marketers and refer back both to what we had achieved in DPDI that we hope to come forward, and also some recent case law that justifies and reinforces everything that we have been saying in our lobbying and messaging to government. So if I start, and bearing in mind what we believe is important is the recitals, Recital 4 of GDPR is probably the most important because it says the right to protection of personal data is not an absolute right. It must be balanced and considered in relation to its function in society and be balanced against other fundamental rights in accordance with the principle of proportionality. And it goes on to say that regulation respects all fundamental rights and observes the freedoms and principles, etc., but very importantly, including the freedom to conduct a business. And the way we look at what we do in our sector is we attract and retain customers. Or if you're a charity, you attract and retain donors. And you cannot have a business or you cannot have a charity with that opportunity to attract and retain customers, or you don't have a business at all, or you don't have a charity at all. So we think that important balance between the right to privacy and the freedom to conduct a business is essential. There are other rights that may come into play, like the right to employment, the right to health, and so on, that may come into a balancing test. But essentially, those are the two things. How do you balance the freedom to conduct a business with the right to privacy and personal data? And one of the critical amendments around proportionality that we had achieved in DPDI was the inclusion of an illustrative list of examples of the types of processing that may be considered legitimate interest. Because if you look at GDPR, it has 6 bases of processing, of which for marketing, the 2 most relevant are consent and legitimate interest. But in the implementation of GDPR since 2016, it has become widely assumed across society, not just in marketing, that GDPR requires consent. In fact, these bases are equal. And in many use cases, data protection officers, compliance departments, and lawyers advising large major brands as well as medium-sized companies have advised that it was safer to use consent in all circumstances, and therefore missing huge opportunities to communicate with customers by legitimate interest. So we had achieved this, and what we did in determining which illustrative examples we should use with the government is to pick up examples that were in GDPR text already as recitals, so there could be no doubt that this was compliant with EU data protection approaches and not risk adequacy. So you'll see the proportionality as described in recital 47 that talks and really gives the framework for legitimate interest. And I won't take you through all of that, but I will show you at the bottom that the processing of personal data for direct marketing purposes may be regarded as carried out for a legitimate interest. And that's critical. That was taken into main text GDPR, giving even greater confidence to use it. And I won't take you through the other 2, but just to say that point B in the revision was recital 48 and point C was recital 49. And I'll just talk now about the recent court case in which the Information Commissioner's Office 3 or 4 years ago took out an enforcement notice against Experian. They also went after other data providers, such as TransUnion, Axiom, and others. But the case that proceeded was the case against Experian, which was brought on two bases: that they didn't believe Experian could use legitimate interest as a basis for the processing of data for third-party purposes. So Experian had based all of their third-party data that they would share with companies on the basis of legitimate interest. They challenged Experian's legitimate interest impact assessment, and they challenged some of the privacy notice approaches to transparency that Experian took in a layered privacy notice. And both the first tier tribunal and then the completely rejected the ICO's point of view. The ICO appealed to the upper tier tribunal, which rejected in full the ICO's appeal. And what we have now is case law on these important issues of transparency, proportionality, and legitimate interest. So one important part was that in paragraph 95, the upper tier tribunal said, identified the issues that must be considered in proportionality. And again, I won't take you through all of it, but what's really important is that the consequences of processing, including the nature and degree of harm or benefit to the data subjects that may result. So what they're saying in this court case throughout is the benefits of the data processing, whether that might be in the form of relevance to customers or more efficient marketing spend to marketers, or reduction in environmental harms. If you're, say, in a traditional paper-based direct mail and you reduce the amount of paper you use by having better targeting, or improve productivity for the economy, because if every company invested their marketing funds better and achieved more ROI, there would be greater productivity across the whole economy by having personalization and relevance of offers. So really important that you can take into account the benefits of the processing and not just potential risks when you're doing a balancing test. And importantly, also the costs of the controller of being compliant with the legislation can be taken into account where it's appropriate. So that's really important. And I love this slide, and it's going to be a little bit boring if I read what's on the slide, but there are some really important findings. These are verbatim extracts from the court case, which is now established case law because the ICO has decided not to appeal further. So this is where we stand, and I'm just going to read a couple of them. Mr. Hume accepted also that the report that the Information Commissioner had compiled in respect to data broking, not specifically Experian, failed to present a balanced account of Experian's processing, and he accepted it did not include any of the benefits of the processing for data subjects in wider society. We accept also that in reaching a decision, the Commissioner and this panel must have regard to the regulatory decisions in respect of the economy, the environmental impact, and positive benefits for consumers of the processing, which appear from Mr. Hume's evidence not to have been taken into account in the enforcement notice. And the ultimate conclusion, we are satisfied that the Information Commissioner got the balance wrong in terms of proportionality in exercising her discretion, because the Information Commissioner had fundamentally misunderstood the actual outcomes of Experian's processing. And that's because Recital 4 says the right to conduct a business must be balanced with the right to privacy, and there are huge benefits to the customers, to the company, and to the overall economy of what we do in creating personalized direct communications. And if there's any doubt about the legal status of the recitals, they also very clearly observed that Recital 47 of GDPR recognizes the direct marketing may be regarded as a legitimate interest. So when we call for the recitals to be given the legal certainty of main text, actually the courts are doing that already, but it just would be nicer and easier if the legislation was amended to make that definitive. I won't talk about this except to say that as we were going through DPDI in the Lords, Baroness Kidron proposed 40 to 50 specific amendments to GDPR that would have increased protections to children especially in areas they didn't think the online safety bill had gone far enough. But in actual fact, none of those would be necessary if people felt they could rely on recital 38, which very clearly, in a clear statement, gives greater protections to children than to adults under GDPR. So coming back to things that were in the text of Data Protection and Digital Information Bill that we think are important to include going forward in any future legislation. Firstly, the definition of direct marketing that was in the Data Protection Act of 2018 was added to GDPR and PECR, so there would be one single definition of direct marketing in the UK's data protection framework. And the definition of direct marketing is not what the average person might call direct marketing, which is often assumed to be just direct mail or telephone. Direct marketing in legal terms is actually the communication by whatever means of advertising or marketing material which is directed to particular individuals. So in other words, all of personalized digital advertising or personalized social media messaging are considered direct marketing for the purpose of the legislation. But of course, if that's the language that our industry used, we never would have evolved the name of the DMA 4 or 5 years ago from the Direct Marketing Association to the Data and Marketing Association. But suffice it to say, we cover the full scope of the government's definition of direct marketing under our remit as the Data and Marketing Association. This is one in privacy and electronic communications regulation. So I know all of you are certainly email marketers in what you do. PECR requires consent for email marketing, except in the case of existing customers or potentially prospects, where you can use the soft opt-in, which effectively is an opt-out. That was not available to non-commercial organizations such as charities because of the way the legislation was written. So we worked really hard. We have about 100 members who are in charities to get the same soft opt-in for email extended to the non-commercial sector. And we will continue to fight for that to be included in any data protection reform, because it's absolutely unfair and not right that charities cannot speak to donors in the same way that companies can communicate with their customers. One of the biggest successes was an ongoing effort to eliminate cookie pop-up banners as part of the customer experience. So as we know, every customer journey to a website is virtually interrupted by cookie pop-up banners that are intended to achieve consent, but don't actually achieve any meaningful consent. So the former government's objective was to eliminate cookie consent banners altogether. But in this legislation, we did not get all the way there. What the legislation did was it exempted consent for statistical purposes for own use, so including, for instance, your use of Google Analytics or your page tracking, enhancing website functionality like delivering personalized experiences to your customers, security and software updates, and emergency assistance. And what the net effect of that was that for those businesses that are not advertiser supported, who only collect and use data for their own purposes as a business, that they most likely would have been exempt from having to have cookie pop-up banners and managing consent. So we think that would have included all B2B websites, provided they were not advertiser supported, all pure play e-commerce sites, provided they were not advertiser supported. Of course, it depends if you were potentially doing some activities that might fall in to digital advertising and retargeting, but provided you're just using the data for the management of your own relationships with your own customers and prospects, and for the improved performance of your own website, and things like shopping cart abandoned, email triggers, and so on, you very well probably could have been exempted from having to have cookie banners under this legislation. And we will fight hard. That had cross-party support, unanimous cross-party support. There's no reason why this shouldn't come back if there is an AI and data protection bill. There was quite a lot of provisions around market research. The important thing was that the bill clarified that any provisions related to scientific research covered scientific research in academic and commercial settings. So not just big, large-scale research programs going on in prestigious universities, but all private sector research and development behind finding new products and services for the modern future, whether that's new technologies, whether that's AI, whether that's new medicines, new genetic medicines, new molecular medicines, really all the future generation of products gave clarity around how data could be used in studies, and particularly the ability to carry forward consent from one study to further studies as you evolve solutions, which is really important in the area of medical research in particular. This was a particular DMA clause that the government put in on our behalf. It may not be widely known, but GDPR actually creates co-regulation of data protection legislation for the first time in history. And in Article 40 and 41 of GDPR, it states that the Commissioner shall encourage the drawing up of codes of conduct intended to contribute to the proper application of this regulation, taking account of the specific features of the various processing sectors. Associations and other bodies represent categories of controllers may prepare codes of conduct. So what it's really saying is the best people to understand how to apply GDPR for data processing in data-driven marketing is the Data and Marketing Association and the members of the Data and Marketing Association who understand what the processing involves and can work with the Information Commissioner to determine how best to apply GDPR. And when we were working on a code of conduct for direct marketing, and remember that definition I told you earlier, quite late in the day, the ICO's lawyers determined that a code of conduct for direct marketing under GDPR could only include GDPR issues. But I think you'll all know that you cannot have direct marketing under that definition without covering email, without covering social media, without covering text messaging, without covering any of the issues that are covered in the Privacy and Electronic Communications Regulation. So within DPDI, the government had tabled an amendment that established codes of conduct and collaborative regulation for privacy and electronic communications issues as well, and included the magical sentence, a PECR code of conduct can be included in the same document as a GDPR code of conduct. And that would mean that we could have had a code of conduct for direct marketing under the government's legal definition of direct marketing with companies that were signatory organizations to that code of conduct having complaints about their marketing adjudicated by the industry monitoring body under delegated authority from the ICO. So in short, signatory organizations would have had complaints investigated by the Data and Marketing Commission, which contains genuine expertise on the processing our sector does, and not by ICO investigators who may have very limited knowledge about what our sector does. So that was an important loss, but again, one that was non-controversial and we hope to bring back. I think really importantly, there was a lot of change to the ICO, our regulator, and how they would operate, starting with changing that from being a corporation sole to being a corporation, a corporate body with non-executive directors and non-executive directors drawn from industry to oversee and advise the ICO on how to go about their business. And in particular, the legislation reflected what we saw in Recital 4 earlier, that the ICO must consider the desirability of promoting innovation and the desirability of promoting competition, and not just consider privacy on its own. It must actually give regard to recital 4 and balance properly the fundamental rights rather than considering privacy to be absolute. So again, those were important changes and we hope they should come back. Again, the ICO supported these changes. All the political parties supported these changes, and there's no reason why we can't recover the situation. Now, I'll just in my last few minutes come back to data adequacy because that was the #1 priority of our members in consultation. And the privacy activists did get out and about saying that some of the changes, especially around legitimate interest, could potentially risk adequacy, or some of those changes to the ICO could risk the independence of the ICO. And so we looked at every European Court of Justice case related to legitimate interest in advertising and marketing dating back to original data protection legislation in 1995. And in every instance, the European Court of Justice ruled that any interest that is legal may be a legitimate interest. Therefore, that illustrative list we added to Article 6.1f GDPR was totally appropriate. That no member state may limit the scope of legitimate interests, that the processing must be necessary to promote pursuit, which has always been the case, and that the processing is proportionate and balanced with any risk to the individual. So you have to do your legitimate interest balancing test. And the opinion that I like most is quite a long one written by Advocate General Bobek in the Fashion ID case. But he does conclude, and this was a case, by the way, that included Meta and some of the activities they were doing. I would agree that marketing or advertising can, as such, constitute such a legitimate interest. And just to confirm that further, I chair our Federation of European DMAs, which is 21 DMAs across the EU, with our lobbying center in Brussels. But we have had codes of conduct under Articles 40 and 41 of GDPR approved in Austria and Italy, both of which are based on legitimate interest. The one in Italy is actually on purely B2B data, and it B2B third-party data, and is based solely on legitimate, it's approved by the Italian Data Protection Authority. So I'll just come back and do a little bit of promotion. I mentioned that skills is a really big part of our agenda, and we had funding from the Department for Education. And in data protection principles of accountability, it's really important that practitioner skills are up to date. So we have a digital marketing strategy bootcamp that's been funded by the government 90%. It's over 100 hours of learning, 1 day a week for, I think, 16 weeks. You'll learn how to plan campaigns that meet strategic objectives, how to set budgets, how to analyze and measure results. And what I should have said there, by the way, it always covers your legal responsibilities and obligations. So it's really important that all your teams understand the legislative framework so that you don't always have to defer to the data protection officer and the legal and compliance teams, which sometimes don't understand marketing hugely well. So that's 90% funded for SMEs and 70% funded for large corporates over 250 employees. So let me know through the follow-up that will happen after this event whether you're interested. And I'll just note that the DMA, we work really hard to support the interest of the industry. We base our work on really 3 core areas. We call it the 3 R's, but it's not reading, math and arithmetic. It's resources, relationships, and representation. So what I've been talking to you today a lot about is our representation, the work we do to support your interest, the government. But we also have a wide range of research, member engagement events, training. Our membership includes an online learning platform with 250 bite-sized learning modules that's available 24/7, learn as you go. Lots of relationships built through our 18 community councils. Everything we do is by the industry, for the industry. And really, we'd welcome any of you who are not members into our community of members for pricing that starts as little as $4,995, depending on the size of company, available to an unlimited number of employees in your organization. So again, Spotler will share some follow-up and a link to me if anyone is interested in having a conversation.
So thank you very much, Chris. That was really, really interesting. If anybody wants to find out more around Spotler, then by all means, obviously, you can request a demo. For the customers on the call, contact your account managers. And obviously, we're up for general chats anyway, so feel free to speak to us, to have a chat with us. But yes, from a marketing automation point of view, if you're interested or you're looking at other products in the industry, we'd love for you to consider Spotler.